This is Michael Popok, Legal AF. Elon Musk and X is trying to go to the United States Supreme Court on a writ of certiorari, asking them to take up an appeal for the next term about whether they had a First Amendment right to inform Donald Trump that the special counsel was going after Donald Trump's Twitter account, all of his DMs, all of the activity around the Twitter account, without informing Donald Trump that that search warrant or that subpoena was being complied with. Why? Because the judge at the time, Beryl Howell, the chief judge then of the DC Circuit Court, made a determination, just as she would or any magistrate judge would, that is more likely than not, or there's probable cause to believe that Donald Trump would try to interfere with the execution of that subpoena or search warrant. And we know he did that in Mar-a-Lago, if not other places, that he would try to delete or destroy evidence and even maybe be a flight risk. And based on that, the judge said there is a non-disclosure order in place. She instructed X, which was the target or the recipient of the search warrant or the subpoena, not to inform Donald Trump and to turn over these reams of data. Now, Donald Trump operated that account while he was president. So of course he would have had some sort of assertion, right or wrong, of executive privilege. That issue, very testy, Judge Boasberg shot down the lawyers for Musk, particularly Seth Waxman. And we did this reporting about a year ago in which she said, I believe, is your client, Musk, trying to curry favor with Donald Trump? Is that why he's arguing about the non-disclosure agreement? They said, no, Judge, this is the First Amendment rights of the social media platforms. We should be able to tell our users that they are the subject of a search warrant or subpoena. And the judge says, not when I've made a determination that it's subject to a non-disclosure agreement. And then after she did that, she found that they were almost in contempt, Musk, for not complying appropriately with the requirement to turn over the data. They were slow-footing it, right? Because they didn't want to comply. And that's when she said, is your client, Musk, trying to curry favor with the president, the former president, who he wants to re-platform? This whole issue about the legitimacy, the constitutionality of a non-disclosure agreement that's applied to a social media company is at the heart of this new writ of certiorari. Now, it has to be granted. There has to be 4 votes to take it up and 5 votes to ultimately side with Musk. And it starts, first stop on the train, because this is filed in DC with the Supreme Court, is going to be with the Chief Justice Roberts, but he'll throw it to the entire panel. Now, this is not going to be a this year issue. The term of the United States Supreme Court is effectively over. It starts the first Monday in October, and it ends in sometime in June. It's sort of like a soccer game. You don't know quite when it ends until there's a buzzer and a lot of screaming and crying. Same thing with the United States Supreme Court. It's going to end soon with the issuance of the last batch of Supreme Court decisions that are coming out. We're waiting for them on gun control. We're waiting for them on abortion. We're waiting for them on immunity for Donald Trump. We're waiting for them on obstruction of an official proceeding, and whether that's going to survive an appeal as used against the Jan 6 defendants. We're waiting for all of those. It'll come out in the next week or two. This will be for the next term. And only after there's a caucus, a conference of the justices, they sort of do a little straw poll about whether they find the appeal interesting and they want to take it up.
How much do you think you're paying in subscriptions every month? The answer is probably more than you think. Over 74% of people have subscriptions they've forgotten about, myself included. It drives me crazy. I definitely do this. And one time I forgot that I had subscribed to a tablet that I no longer even use. And it was literally charging me every single month. But thanks to Rocket Money, I no longer am just wasting money on these ones that I forgot about and that are just leaving your bank account every month. So Rocket Money is a personal finance app that finds and cancels your unwanted subscriptions. It monitors your spending and it helps lower your bills so that you can grow your savings. With Rocket Money, I have full control over my subscriptions and a clear view of my expenses. I can see all my subscriptions in one place, and if I see something I don't want, Rocket Money can help me cancel with just a few taps. I love how the dashboard shows me this month's spending compared to last month. I love it and hate it because sometimes it's not so great, but I can at least see what my spending habits are. They also help me create a custom budget and help me keep my spending on track. Rocket Money will even try to help lower and negotiate your bills for you by up to 20%. All you have to do is submit a picture of your bill, and Rocket Money takes care of the rest. They'll deal with customer service for you so you don't have to. My least favorite thing. Rocket Money has over 5 million users and has saved a total of $500 million in canceled subscriptions, saving members up to $740 a year when using all of the app's features. Stop wasting money on things you don't use. Cancel your unwanted subscriptions by going to rocketmoney.com/legalaf. That's rocketmoney.com/legalaf.
Now, one of the things that may motivate the MAGA right wing on the United States Supreme Court to take up this appeal is that it went en banc, meaning the entire DC Court of Appeals eventually heard this. And while it was the majority upheld, most of the en banc panel upheld Beryl Howell, the chief judge of the Times, ruling in which she almost found X in contempt, forced them to turn over all the documents and data, which were then mined by the Department of Justice and the FBI and used against Donald Trump in the DC election interference case, the one that's on hold in front of Judge Chutkin, as we await for the immunity decision from the United States Supreme Court. There were 4 members of the panel, the en banc panel, mainly the right wing and the conservatives, including one of them that was part of a recent gag order decision by the DC Court of Appeals. 4 of them thought in a scathing terms that Beryl Howell was wrong and that she had not properly balanced the potential application of executive privilege when she was making the unique decision about Donald Trump, social media, and the use of a non-disclosure order. And so they thought that the trial judge gave short shrift to that, and they would have reversed. That was 4. They were outnumbered about 8 or 9 to 4. But that, you will see, will be the thread that will be pulled on this giant sweater by the MAGA right wing. And they'll likely get their 4, if not 5 votes on this issue. And they'll have to decide, as we've seen in them do in other oral arguments and decisions, the application of this overlay of the executive privilege of the president on top of the non-disclosure agreement and the First Amendment rights of social media, and kind of analyze it all through that lens to decide whether, as in our constitutional republic, this will be the ruling of the Supreme Court eventually, whether a non-disclosure agreement can be applied to stop the disclosure to a former or current president if there is executive privilege implications of the turnover of his material. Their argument was they should have given him time as the former president to try to assert executive privilege, have it litigated before all the documents went over to the government, to the Department of Justice. That's the fundamental argument. We'll follow right here on the MeidasTouch Network, just like we always do. We think it's a slow news summer for the the Supreme Court. As soon as they make this last gasp of rulings, it won't be, because we'll be getting these petitions that as soon as they get back in the first Monday in October, they will then look at this pile and decide whether this particular writ will be pulled up. But no, this will not be decided on an emergency basis or otherwise during the summer. Supreme Court, frankly, doesn't meet in the summer. We'll have to pick it up again in October, and we'll follow it right here. Follow us on the MeidasTouch Network. We're called Legal AF. It's a podcast. We curate the top stories at the intersection of law and politics. We bring it to you right here, just like this one, except we do it with co-anchors. Wednesday, I do it with Karen Freeman-Ignifilo. Saturday, I do it with my co-founder, Ben Meiselas. And then on hot takes like this one, to keep you at the moment, at the market, up to speed in all things legal and political. So until my next hot take, which is like this one, and if you like this, leave me a comment and a thumbs up. It keeps me on the air. It's not ego, it's algorithm. And until my next Legal AF, again, Wednesdays and Saturdays, and free subscribe to the MeidasTouch Network, by the way. Help them get to 3 million free, yes, free subscribers before the election. We're building this network with our bare hands with your help, I assure you. And then we have another way to support Legal AF and the contributors there. It's with patreon.com/legalaf for exclusive content, teachable moments, Popok talks. It's a TED talk meets a law school class, and it has a baby. That is patreon.com/legalaf. So until all of that, this is Michael Popok reporting. Heary. Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.